Hello, everyone. Welcome to Go Global World podcast. This is the type of channel where you can ask your questions from invited experts in specific fields. And today is probably one of the hottest topic we have on the market is AI. And with AI, there are so many advantages and new challenges coming in. And today we're going to discuss how to avoid legal landmines building an AI product. And we have an amazing expert and a speaker joining us, Dmitry Dubograev. I will present him in a second. With that said, I'm going to show you a few slides about Go Global World, what we do. Then I'll let Dmitry to start his talk and present himself. We will have simple rules. When you want to ask any questions, you can add your questions in the chat or raise your hand. If you want to ask your question verbally, we will let you speak in the order we receive hands. And let's make this engaging session. So take screenshot of the session, share it on social media, spread the word. So let's make it count. With that said, I'm gonna present the screen. Just a second, let me share my presentation. All right, so this is the talk we have today. We were in discussion with Dmitry how to share his expertise and knowledge to our global audience, because Dmitry works a lot with different types of corporations and companies in the United States, and he has a lot of very, very important expertise that you might be very much interested to hear from him today and maybe in the future. Now, about Go Global World. Go Global World is a group of companies. We have three companies under GGW group of companies, and Go Global World is the platform. It's a number one place to do warm connection for startups and investors. We have about 5,000 active investors, VCs on our network, and many thousands of startups. And mathematics is deciding who's relevant to who among verified vetted networks. So we literally check every single person registering on our platform, ensuring it's a real startup, it's a real investor. It's their own intention to come to the platform. So then the technology is helping you, accelerating your access to the right network you're looking for and which is looking for you as well. To kick things off and get started with our platform, just go on our website, create your free profile and see how things can help you there. The other company we have is GGW Services. This is where we do help with incorporation in the United States, in any state. We do tax filing, tax compliance, accounting, and many other things such as payroll, financial support, in terms of reporting for global founders. If you want to know more about our services, the prices, what's included, just go on our website, goglobal.world/services. And we also have an investment arm. We review companies for potential investments, GGW Ventures. If you are a high growth company like with potential to grow really fast, please reach out to my team and we will be happy to review your deck. So these are our contacts. This is my LinkedIn and my Telegram if you want to reach out to me. And this is my this is our website and our email. So then you guys can be in touch with us and also start your GGW profile. With that said, enough about Go Global World. Let's get to our webinar. And webinar is about legal challenges and landmines that you can face, and we will help you walk you through how to avoid them. Today we will have Dmitry Dubograev. He has an excellent expertise. Dmitry is an American lawyer and American founder and managing partner of the law firm Femida.us. The firm has legal practice and is focused on representing the interest of more than 350 clients around the United States. And so they have expertise through entering Western markets in the field of information technology, software, and security, telecommunications, and entertainment. With that said, Dmitry has over 20 years of experience in corporate and intellectual property law, focusing on legal aspects in startups and internet industry, mergers and acquisitions, investments, corporate formation, and management technology. So he works with technology transfer and licensing projects and international commercial transactions. He has a very intense and large practice in the field of corporate law and IP, intellectual property, specializing in legal aspects of new formed companies. He works a lot with small businesses, medium-sized enterprises, and he has a lot of expertise in advanced technologies and the internet from legal perspective. With that said, let's welcome Dmitry to the stage. I'm super excited to have you, Dmitry. Let's kick things off. The stage is yours.
All right, thank you very much for the introduction. And before we get to the lecture, indeed, we work with Go Global for a while now. And one of the big things that I think our client appreciate working is we truly work with Go Global in tandem, and the responsiveness, the reasonableness of the charges, effectiveness of the advice, it's been very appreciative by our clients. So I also, we refer to a lot of clients to Go Global. So I recommend your firm very much, as a really good value added, basically service almost to any IT company. Shortly about us, just to add on, we are a firm of 24 years old. We represent essentially IT companies. That's our focus. And we try to not only stay sort of conservative, considering our experience and expertise, but also making sure that we are on the edge of new technology, and not just from technological standpoint, but also from the legal standpoint. So we're going to go today through AI and things that people don't right now don't consider important or don't address, and we try to go over things that I think every single company has to be at least cognizant about, and talk and think and have strategies regarding AI. So lo and behold, we're gonna do today sort of a combination of traditional law with a little bit of a law that essentially goes around traditional aspects of any IT. So the first level of, and most of our businesses in IT essentially wrapped around copyright. So what is copyright? So copyright has three distinctive features. It has to be fixed, it has to be original, it has to have minimum level of creativity. And this is how the government recognizes, essentially since Napoleon Code, the copyright. So what is then AI? How does AI fits within these three parameters? So copyright protects code, graphics, characters, rules, not really. Language, no. Ideas could be, but it's mostly expression of the ideas, not the ideas themselves. Most ideas or inventions are really protected by patents. So the biggest thing before AI in the industry of software development, what I would consider, and at least for my practice, is the problem of so-called self-plagiarism. What I mean is that when the company develops in services a product for someone, and a good example is, let's say a company develops a product solution for a hospital, let's say for patient management, and then it goes around and does the same product for someone else. And the question is, like, how much of the prior knowledge, prior expression, and prior coding they used in the second project. And oftentimes they don't realize that it's called self-plagiarism, meaning that if you write a song, and who were at my previous lectures, Creedence Clearwater Revival wrote a song and then sold it and then they wrote similar song, and they were sued for plagiarism. So one of the things that people don't realize that you can actually plagiarize your own work if you're already committed to transfer the work to someone else. This actually, this problem persists, but it's now being exacerbated by AI. So let's go over and see basically how we address basically combination of AI copyright. Copyright essentially is arises automatically, meaning that if you wrote a book, wrote a song, wrote a code, it's actually you automatically have a copyright in that work. But still put a notice, and that used to be more important than it is now. But put a notice because it's a warning, it's declaration that you're the owner. It's a little bit showing the timing, and also if there's an infringer, it might make him a willful infringer if somebody steals your code. So you still have to register. So presumption that you're the author, it's proof and evidence compared to the violator. It also helps payment of legal fees, because if you have a registered copyright, then if you win the case, the court is likely to cover your legal fees. And then there's a thing called statutory damage. So it's like a fine, but it actually levied against the infringer, but it is paid to you. And you can ask a judge up to $150,000 per each violation, which is not a bad compensation. So the biggest problems right now in the IT industry getting copyright other than self-plagiarism is so-called unintended co-owners. So you work with someone, you developed an article, and then basically you didn't really write any contracts, and so the person that contributed to, let's say, 1% of your work actually could be your co-owner. And that's if Lennon and McCartney wrote a song together, whoever wrote 51 or 49% doesn't matter, but it does matter in our industry, in the code. So make sure that if anybody contributes to your work, it's made work for hire, and you don't get unintended co-owners in your work. The second problem is who owns derivatives. So if you work for somebody and your customer decided that he wants green instead of the yellow button. So if you develop that portion, would that be yours or would it be your client's? So ownership of derivatives is a really sensitive issue. And basically now with AI, the biggest issue, who now owns the code? And so why this issue even arises right now? So it used to be that you have a fair use. So fair use means that you take somebody's work and you can use it without asking. And there are exceptions for teaching, for criticism, for humor, or for your own use. For it used to be that if you have a book but you don't want to spoil it, you do photocopies, or you take pages of the book on the plane. That's even though you copy it, it's probably fair use. But basically, it used to be that there is a transformative use, secondary use, meaning that you add value to the original, transform in creation of new information, new aesthetics, new insight and understanding. So what happens is that if you take somebody else's work and you redefine it, you basically make something else new out of that. Would that enough of a transformative use? And usually fair use is to protect the enrichment of the society. So let's say you read 6 physics books, and then all that knowledge is instilled in you. But based on that knowledge you acquired, then you produced a Nobel Prize worthy invention. So how much of your invention was a derivative, or was it a fair use of the physics books that you read? And you could see how I'm leaning toward data set, AI learning, and that's what our aspect is. But we're gonna dive in a little bit more in the traditional copyright. So, and lo and behold, Andy Warhol, and everybody knows who he is. I highly recommend his museum in Pittsburgh. So there was a case called Andy Warhol Foundation versus Goldsmith. So you probably well aware of Andy Warhol's work, and this is his masterpiece, basically Campbell tomato soup. I think it was sold for a few $1 million, and obviously, Marilyn Monroe. So, but the case arose based on this picture of the artist formerly known as Prince. So Goldsmith, being a journalist, he basically took this picture and wanted to sell it to a magazine. Then Andy Warhol took that picture and created a transformative, in his words, work. So he basically, colored the picture. So again, on the left side, original picture. On the right side is quote unquote derivative work. So did he really make a new transformative copyright? And for people here, for those of you who think he did, maybe in the notes, put plus. And if you think it's a derivative work, not really worthy of the status of new work, put minus, please, in your notes. And I was wondering what kind of the quotes votes we're gonna get. So we get both minuses and pluses almost evenly, interestingly. Okay. So this case actually lasted for almost 10 years. Not only it lasted, it actually, both Prince and Andy Warhol were dead by the time it ended. However, the Supreme Court of the United States said that, was it transformative? And the answer is no. So lo and behold, essentially, the Supreme Court called Andy Warhol a crook, but a very good salesman. So there are different tests to see, was it enough of a transformation to make it into a separate work? And there's an economic test, whether they were, basically competing for the same magazine fees to publish. So right now, the Supreme Court said no, that the just painting of somebody else's photograph, particularly in the same field, would not make it transformative. So why is it important to us? AI generates output, such as code, design, music. So who owns AI generated content? So as of now, pursuant to the US law, copyright law generally protects only human generated stuff. And right now, both courts and the law are still grappling with anything that's been AI generated. I know that in China, they have actually registered a copyright for a character that was completely 100% basically generated by AI. In the United States right now, basically we struggle with copyright. Almost every application for copyrighting the code, registering copyright for the code, comes back as like, oh, that looks like AI generated. And again, if it's AI generated, fixed, original, minimum level of creativity. So the law on the last two aspects basically says no, it's not, basically because it's not human, there is no creativity in the robots. And hopefully, the Terminator doesn't listen to us right now. Otherwise, we'll have to jump and see whether we can save John Connor. So US copyright will not register the copyright of any AI-generated contents unless it contains sufficient human authorship. So the office provides two examples of potentially sufficient authorship. the selection and arrangement. So basically AI generated elements and the whole work and how you put it together. So it could be copyrightable, but not the elements themselves that AI generated. And the second, a human author modifies an AI generated element such that the modification can be copyrightable. So basically, not the AI generated, but AI assisted. And in both cases, human author changes do not affect copyrightability of AI generated work. So AI has no creativity. But as we see, there is a way, a loophole as to how a human using not AI generated code, but AI assisted code or AI assisted content can actually have its copyright protected. Why is it important? Because if it's not copyrightable, it's really not yours. So remember, there are two specific trends in human development, right? One is to get stuff widely spread and hopefully for free. What's the other element? We call it entrepreneurship. Somebody else called it greed, meaning, well, if I created that stuff has to be mine. So there's always a fight, right, to make things public and work for human, basically nature. And the other is, well, pardon my French, screw the world, give me my money. So this is always a struggle between these two trends. And today we actually going to be talking more about greed rather than human element. Okay, so AI generated code is not copyrightable unless sufficient human authorship, and this is where the key lies. So what the hell does it even mean? What is sufficient human authorship? And as we saw with Andy Warhol, just painting stuff between the lines was not sufficient human authorship. So how do you deal with AI? Running AI, basically an IT company. First of all, with upstream. When you do an upstream development with developers, so making sure that your developers don't use AI generated code. And if they do use it, then if you do need them to use it, define when, how they can, what are the parameters, identify pure AI, and then identify to ideas, originality, architecture of the build. So basically, you really need to make sure that when you have AI assisted code, your human contribution is actually well documented. So basically, you have an argument that whatever you have created was more done by a human rather than AI or a robot. So basically, you have to really document and annotate changes, arrangements in human contribution. We work with a few clients right now to provide for that. And unfortunately, developers obviously hate it because it adds work to them. However, the irony here is that the fixing the human element here can also be automated. So we have a robot fixing and annotating and helping human to record human contribution. Isn't that the irony in itself? So, but at the same time, this is the mindset that you have to set up in your company, in your employees, in your developers. So it's time tracking, prompts. If somebody done 10, 15, 20 prompts, don't delete them, save them. So save progress and have a correlation between efforts and versions. So how do you do with downstream? So meaning to client, user, or licensee. Remember, you are a little bit on the verge of having your code similarly to like an open source. Used to be the biggest problem. Now it's AI generated code, which is possibly yours, possibly not yours. So how do you actually protect yourself against your clients now try to steal your code? So basically your client and its lawyers need copyright. So meaning that you have the copyright, you license it to them. Why? Because they're paying for it. If you license to them something that is not yours, why they even should pay you something, for something that you don't own? You usually, if you rent the car, you pay the person that gives you the car. It's their car, you pay. So, but if it's you give them something that is not yours, but it's public, why they even have to pay you? So AI generated code is now new, open source problem. So quote unquote infected. Make sure that when you work with someone and their words work for hire again only works in copyrighted code. So if you work for a client and a client says, "Oh, I need you to do this for me and create and customize the ERP or CRM or something," and you say, "Oh, sure," and there are magic words, work for hire. If client hired you and made you do work for hire, you can't really use AI generated code. You can use only AI assisted code. Otherwise, you are what? You in breach of the agreement with the client because you're delivering deliverables that again are not yours and not even the client's simply because it's not human. So basically make sure that where you have agreements, right now the companies are saying, well, there's no AI. Or is it fully copyrightable? Is it all human produced? These things are now trickling in into the agreements. And if you are on the receiving end, you should think about you owning a license or, being an assignee of that copyright. However, if you on a given side, again, be concerned because if you said, well, no AI or fully copyrightable, and then one of your developers generates AI generated code, be in breach. So make sure that you address the issue of your developers using AI. You have to trace it. And again, this is a prevalent problem that actually permeates probably 100% of every single company. I think even lawyers, because I think other than documents and agreements that generate basically help with AI assisted assistance. The agreements by law are not copyrightable. Basically, the law says there shouldn't be a monopoly on law compliance. However, there's a lot of advice, seminars like this one, others that could be done with AI assistance, and so almost every company is now facing the fact that it's either good and really comprehensive and maybe has been cleared and cleaned with AI, or it's not theirs. So again, public use, public good versus greed, or as we call it, profit and entrepreneurship. So it's not only about quantity of the code that's been generated. It's first and foremost, it's about story, it's about flow, about prompt, ideas, etc. So it's really make AI a tool, not a creator. So it's really about your creativity. So as long as you document your creativity, and an argument could be made that as much as you use computers or graphics or CGI to generate images and movies, so AI could be made a tool. Just don't make AI an author, because unfortunately AI will be a flawed author, meaning that whatever AI is generated could be owned by virtually anybody. So now we switch into data sets and prompts. So training data, using copyright material to train AI might by itself constitute infringement. So now you could see there are a lot of movements in the field right now where certain companies says, oh, we only use licensed materials for data sets, or we only use Creative Commons, or we only use open source. So obviously, the more information you use for data sets, and the more proprietary they are, the better output of your AI system would get. So right now, the law says that using copyright materials to train AI could be an infringement. And the leading case that just came out recently, it's Thomson Reuters versus Ross Intelligence. So what happens? So Thomson Reuters, and all lawyers know that it's the owner of basically a system called Westlaw, which is the golden standard of legal use, basically sued AI startup called Ross Intelligence for its unlawful use of Westlaw proprietary headnotes. So what are those? So headnotes are summaries of key points of law, and they are derived from published court opinions. So every court publishes an opinion, and there are headnotes. They are like summaries, and that's how lawyers look at them, how they search it, and maybe even some conclusions that can be made from summaries from those headnotes. So what they did is they actually built an AI-powered legal search engine designed to compete with Westlaw. So they used notes, not the published opinions, but the headnotes to create their own and teach their AI system. Initially, Ross asked licensed Westlaw content to train its AI. Westlaw obviously refused. They said, nah, we're not going to license you our data sets consisting of headnotes. Then Ross said, okay, they engaged a company called Legalese to create bulk memos. So basically, Legalese would log into Westlaw, take all the headnotes, bulk memos, and to the large extent, they will incorporate Westlaw's headnotes that were turned used to train Ross search tool. So, and basically, but the Ross tool itself did not employ generative AI. Instead, the Ross tool was created to field legal questions and output element of already published court opinions, which, as government works, are not protected by copyright. So essentially, Westlaw wasn't really happy about it, sued, and the court says that was a breach. So Westlaw verdict, court, Ross infringed over 2,000 Westlaw headnotes. Headnotes were sufficiently original. Again, court opinions are not copyrightable because it's government work, but the headnotes were sufficiently original to get the protection. Even though the headnotes is derived from the uncopyrightable material, judicial opinions, the court noted that there is a sufficient creativity in distilling, synthesizing, and explaining part of an opinion. And that's, again, we're going back to the greed, meaning that if you sufficiently create, distill, synthesize, or explain, that actually can become a copyrightable material that you can then sell, capitalize on. So the selection and arrangement of facts in a headnote could also be sufficiently original to be copyrightable. So essentially, Westlaw key number system was also operated by a computer program. So there are keynotes, and lawyers, know that an organization of legal topics by simply a key number. So was nonetheless, even organization by numbers was sufficiently original to be copyrightable. So it's not really the effort or the volume. It's really the originality. Again, people's creativity, human contribution was the appropriate test for the copyrightability. And again, my favorite expression, in order to survive, you don't have to run faster than a wolf. You just have to run faster than the slowest deer. So as much as you trying and instilling in your business processes at least some process of documenting your creativity, documenting your efforts, documenting your originality, this is what makes you not the slowest deer. And this is how you survive in court and, honestly, on the market. So other critical legal issues at AI use. In the gaming industry, several lawsuits right now in the gaming industry. Addiction. Maybe AI was so good making the game that essentially made games addictive. And, there are cases when the kid is dying, without eating or drinking water. Also, AI may be so good that it has so-called predatory monetization, especially game purchases, targeting minorities, unfair deceptive marketing practices. So essentially, there's really no objective test as to what predatory monetization is. However, that's an issue. So you just have to be cognizant of that and not taking essentially AI output as true value, that you have to then have a human evaluation of the process. Liability accountability. So product liability, traditional tort. So what is traditional tort? Is who do you assign a fault to? So you have a product, and again, tort also applies to us, meaning IT industry. You produce bad software crashed, broke your computer or erased your data. So you have to assign the guilt to someone. What if this someone is AI? Is it guilty? Is it somebody who basically installed AI? Is it somebody that produced AI? Is it somebody that did prompts? So basically, if AI now acts independently of its creator or user, who is at fault? And that's where law also struggles a bit. And essentially, there were older cases, and now will be newer cases based on AI. It used to be that the leading case was a cruise control in the car start acting up, and I don't know if it was fully true. The court didn't really decide it was or was not, but essentially, let's assume cruise control just randomly start accelerating the car, and the car crashes. So who is at fault? Is producer of AI or cruise control somebody that put the cruise control in the car, or the driver that didn't have sufficient control of cruise control or switch it on when it was not supposed to? So there are many, many issues about liability accountability. And obviously, nobody wants to assign liability to company or person that has the money. So whoever generates output with AI is likely. Also be careful that negligence versus strict liability. There are some laws in the United States that essentially assign strict liability. And courts are currently divided whether developers or operators should be held liable. So what does it mean? So usually, in order for you to be guilty, guilty meaning in a civil sense, and pay damages, you have to have some sort of negligence. So you kind of messed up. You did something wrong. However, there are things that if you are involved in, let's say, operating a motor vehicle, or if you, let's say, disposing of landmines, so you involved in dangerous, inherently dangerous activity. Sometimes the law says it doesn't matter if you were negligent or not, as long as you're involved in dangerous activity, you by itself will be guilty of any damages that you cause. So there is no really causation between you messing up, as long as there's causation of you acting and actually the damage. So right now, the courts didn't really decide whether we should assign AI this strict liability. It's like, is there a human element involved and then liability? Or because you used AI, it doesn't matter. Basically, you are inherently involved in dangerous activity. So be careful and make sure that, again, you're at least cognizant of the quote unquote guilt aspect of your enterprise. So there's strict liability, as I said, regardless of fault cases. So what happened is there is cases right now that are really old, but didn't address liability for defective product design, but the principle is likely to be applied to AI cases, meaning that if AI by itself caused it, and even though there's no negligence, whether the producer of AI system would be then responsible or the one who operates it. So let's say and the case that I mentioned, Toyota, unintended acceleration cases, is when the car decided to take off. So plaintiff sued not basically Toyota, not even the driver, but somebody who produced in the software, and the software bug caused acceleration. So that's kind of what's going to happen with AI use, and that's how the court are going to address the next steps. So other critical legal issues in AI use. So right now, transparency, human oversight, documentation challenges liabilities worldwide. Just be careful, because basically AI, EU proposes AI Act to address all of those issues. However, in the United States, the trend is more to base AI-related liability and ownership, not just the bad part, but also the quote-unquote greed part, on traditional notions of the law, and we're developing precedents, like the one that I told you about in the beginning about Andy Warhol, or Thomson Reuters, and I think that will be basically the guide to develop. But it's also possible that in the United States, the law will be also developed to address those. So one of the things that EU proposes is ban high risk, limited risk AI, basically a gradient system for different types of AI. Also, what's important is privacy. Sometimes AI may collect personally identifiable information, and sometimes it's may volunteer and collect a little bit more than it's permitted or allowed or was consented to. So again, who is liable, and whether you're in control of the dog that you just let off the leash. So be careful. And for that purpose, if you use AI in your internal systems, then it may be worthwhile make sure that you have a valid informed consent. So if your AI is prevalent and in your business operations, and you using personal identifiable information for your marketing important, maybe it's worthwhile to make your consent a little bit wider. Maybe it's worthwhile make it a little bit more transparent to the user, making sure that the user, when he goes onto your site or onto your application, is well informed that it's not only human that is looking into him, but also AI. They might be prying into his privacy. So right now there is a case, Facebook biometric information privacy. So plaintiff alleged Facebook facial recognition software violated Illinois Biometric Information Privacy Act. So that's basically my prediction. That's one of the cases that are going to be, not a golden standard, but at least a standard, a totem pole around which everything is going to kind of revolve, to see whether facial recognition itself and other aspects are personally identifiable information, your location, your IP address, other things that may be critical to the operation of your app. Maybe it's not. So, but these are the cases are certainly gonna pop up. So what are your best practices? What do you do? Try to adopt data and anonymization. So don't use the data you don't really need, but obviously if you use telemetry and you need analytics and marketing, anonymize, and so we will not be personally identifiable information. So update your legal framework regarding PI, make it flexible for your business. And not only flexible, meaning a little bit broader and maybe a little bit more informative for your users, but also make sure it's compliant. Conduct privacy impact assessments. So what you do, how you do your business, it's worthwhile making these assessments and tweaking your legal documents as much as your internal policies. And so basic documents don't exist there just to be there on the site, but also for you and your employees and customers, as well as your internal developers to follow. So make sure that AI data sets also comply with jurisdictional laws like GDPR, CCPA, HIPAA. So GDPR is privacy, CCPA is a type of privacy law adopted by California, and HIPAA is something that has to do with information relating to your health. And right now, there's this a slew of state regulations that are similar to CCPA, but not as intrusive and not as anti-business oriented as CCPA, but there are still state privacy laws. And my prediction is because the federal government role in economy, at least by declaration, is going to subside, there's going to be more private enforcement as well as state enforcement. And we've seen this year that we have been receiving certain things from states to go after companies that are not privacy compliant or other aspect of state regulations. So critical issues, algorithmic biases and discrimination. Well, sometimes, maybe AI acts a little bit more like, racist or, must being, making certain assumptions that civil society decided that are not appropriate in the 21st century. So issues may replicate it, so AI may amplify social biases, may result in discriminatory practices, or maybe outcomes of employment, lending, healthcare, and beyond. So sometimes it's just difficult to detect. Well, it takes a lot of data and analyzes it, and then it would say, well, because of certain skin color, people, you know, have a certain percentage of, let's say, prison population, we're gonna go and have less of treat them as less valuable customers or less valuable part of the community, which obviously is not acceptable in the current society. And it's really, if you make it automated, it's really difficult to detect. And so basically we have a case in 2016 when basically there was a Compass, a risk assessment algorithm that was trying to basically automate how many years do you do in sentencing, court sentencing in criminal cases. But basically, the critics of that system raised the problem that was deemed, at least on its surface, as racially biased. And so the system was basically whether or not that system was providing a due process for people of different backgrounds and skin color and races. So, and that's something that could be viewed, soon in different types of business use as well. So regulations, carefully. U.S. Equal Employment Opportunity Commission, Federal Communication Commission, Consumer Financial Protection Bureau have issued guidances on warning against discriminatory AI use. So if your product or your services fall within communication, and all of us do, consumer or equal opportunity, make sure you read these guidances, study them, apply internally, and have it as part of your employee handbook. So basically, right now, New York City local law 144 requires employers to audit AI hiring tools. So if you use AI in hiring, you must have an audit for racial and other illegal biases. So Algorithmic Accountability Act, which is just only proposed but not yet implemented, would require companies to audit AI for biases and effectiveness. So again, we are now on the verge, not of just AI explosion, but also we are, I think, on the verge of having somebody basically start thinking about AI application and making sure you can commercialize it safely. But unfortunately, as happens often, the industry itself runs faster than basically legal thinking. I don't know, maybe because lawyers sometimes are slower, but I think it behooves all of us to start thinking about the entrepreneurship, about ownership, about compliance, and basically at least have a mindset in your own company that this is now new era, and not just era of AI assisted or AI generated stuff, but it's also a new era in exploring the world of law. And if you have any questions about the aspect we discussed it today, or if you want to explore your compliances, and if you have basically any questions, or you should post my lecture, here are my contacts, and please feel free to send me an email, and I also posted our Calendly if you want to schedule a meeting to review or discuss this lecture or any of the issues in your company. I'll be more than happy to do so with you. And thank you very much for your attention. Thank you for your pluses and minuses, and hopefully I didn't insult anyone that is a big fan of Andy Warhol. I am a fan myself, and but I think the Supreme Court did do the correct assessment of derivative work, and to me, I think it's more important to have an important aspect of human creativity in your work, be it a painting, a song, or computer code. So, looking forward to the questions.
The question. So now let's go back to our kitchen. Now we are back, very cozy and ready for like easy and informal conversation on complex topics in legal and AI. Now, here we have a few questions in the chat. If you want to speak, just raise your hand here. There is a digital hand, and we'll let you speak.
But is digital hand AI generated or AI assisted?
Yeah, we can review legal aspects of that too. Now, the first question is from Thomas Ferner. In Germany, the driver, not the registered owner or manufacturer, would be responsible for driving the car. I can imagine that the driver is responsible for cruise control to work well in German law. Not sure if it's related to the topic, but what do you think?
Basically, as I understand, different countries take different approach. Some take approach that if you're involved in dangerous activity, no matter what happens, it's your fault. Others maybe make it a little bit more of a proximate cause. Basically, well, you kind of have to have a link between what you did and the damage. So it might be that Germany takes one side or the other, but in the United States, I see that the software manufacturer or the cruise control manufacturer might be more responsible than the driver itself, and that's what makes U.S. a litigious country. That after baseball, it's a second favorite pastime. Suing somebody. So in that sense, product liability is essentially not as much as government imposition, but rather private cause of action. So if you did something, you messed up, there will be a bunch of lawyers, we call them ambulance chasers, essentially, knocking on your door and seeking damages. But good question. Again, it's not resolved. I'm not saying that there's an answer to every question, at least, but you have to be aware that there's actually a question. So
we have a quick question from Brett Monat. He wants to verbally ask it. Put him on the stage instead of me. So
sure.
Keep it short, please.
Can you guys hear me?
We don't see you. If you can turn on your camera. Perfect.
The camera is on.
Oh,
Nice. Can you hear me?
Talk it.
Yeah, go for it.
Okay. So more aligned with copyrights, say book copyrights, movie copyrights, not coding. And I get the parameters around some form of human intervention, but are there any different best practices or pending government? I see different laws being passed in Japan than in the U.S. Congress. I don't know, maybe just a comment on, I'm using AI as an assistant to create, fantasy history or whatever these guidelines are that if there's any different thoughts versus coding, which is a little bit more specific in many regards.
Yeah, very good, very good. I think this is where we are going to struggle a bit because I think it's extremely subjective. So, for instance, the government says, well, if it's AI generated or robot generated, it's not copyrightable. So we don't have to look a year, back. Let's say, was it 6 or 7 years? Let's look at Avatar movie, right? There is not one actual picture that it wasn't CGI generated. So can you go and copy Avatar movie and unfairly distribute around the world? Probably not. It's most likely you're going to be sued pretty quickly. So I think part of my sort of, I don't want to say mission, but at least the goal of this lecture is that us lawyers and you as IT leaders are actually providing these standards and providing these standards for prompts or something that's been generated and prove to the government that, we are still more creative than AI, and AI is, gives you the string from here to there. But in order for something to be of that output, there's been a very subjective, high-level process of thinking in order to create what we create. So to me, I think we in the process of developing best practices. So going back to your question, but I don't think they yet exist. As I said, most likely right now, just because everybody's using AI, the AI use itself runs so fast that the courts, regulators, best practices are behind. And I think, like in my practice, we at least try to catch up with my clients and tell them, listen, you really need to think about it, because in 3 or 4 years, somebody will come in and say, I want to buy your code. And you say, I can't because it's not mine. It's AI generated. So I'm trying to look forward and prepare people for the questions that will be asked, and make sure they're able to at least answer them and to protect. But your question is excellent, and I think it's the whole point of our today's dialogue.
Yeah, I mean, just one quick thought. I mean, in the work for hire space on code specifically, what's the difference between hiring AI to write my code and a work for hire agreement with a human? If it's my construct, here's my idea, I want to build this code, I hire 5 people that are humans and 5 AI, and they're all work for hire, but it's my construct.
See, I kind of almost agree with you, but the government just differs right now. It says, like, on your right hand is it's yours. On the left hand, it's really like a public property.
Yeah.
I mean, it's almost, that's why even if you have the 5 AI quote unquote guys working for you, I think it's still, there needs to be, if for anything, just for purposes of fighting the government, to show your construct. So what is your construct? Did you do 10 prompts? Did you revise? Did you yell at AI? To make sure it. Yeah. So I think it's just right now, it's again ironic that we use robot to reflect and almost memorialize our human contribution, which is a little bit makes it certainly challenging. But excellent question. I think it just shows where we are right now.
Yeah.
We are just at the very beginning.
Moving on. Thank you, Brad. We have a few more questions. Another question from Dionysi Sisgigel. Sorry if I pronounce his name incorrectly. He's saying, if I use AI for my work because my employer says so, will I be responsible for any law problems, or it will be responsibility of my employer?
Okay, so interesting. By default, if you do development within your employee, right, and whatever you created actually belongs to your employer. That's what, anybody that is employee of development company automatically assigns authorship to the company. Now, if we go back to AI, if it's just AI generated, not copyrightable, it's really nobody's. So it's not, now we're talking not about the product even liability or who owns it, because if you own it and it's flawed, then your employer is responsible. Then you basically might be responsible on a negligence theory. So you created something that it might be not yours. It's like you going on a bench in a public property and you cut one of the planks, and an old lady sits at the bench and breaks her arm. Well, it's really not your property, but you're probably responsible for your action. So again, it's an excellent question, and I think we're in the process of development, and depending on the approach of the courts, depending on the country, and depending actually on your own actions, like if your actions were negligent, were they not negligent? Were they grossly negligent? Did you actually did something willful? You did an AI and said, listen, I don't like my employer. I want this software to start sending emails that my employer sleeps with his secretary, and was it malicious? Was it negligent? So I think it's so fact driven that we just don't have enough precedence right now to evaluate on a generic level. But as you saw with Andy Warhol, why did it go to Supreme Court? Because the courts kept saying, one court said it was transformative, another court said it wasn't, then Supreme Court again said it wasn't. So despite the fact that Andy Warhol's art has been recognized by billions of people, and I think his sales in the past decade were like $8 billion of his artwork, still it's something that you have to be cognizant of, and I think it's so much fact driven. So excellent question, and exactly to the point that who is responsible. And that's one of the key issues always in the contracts and legal disputes.
We probably take one last question. So we have one comment and one question. The comment from Alex Chijik, he's saying not a question, but a comment that analyzing AI risk for your companies twofold. One, reviewing your internal work that uses AI, and two, reviewing your company's contracts with AI vendors. If you don't look at the AI vendor contracts, you may compound your risk related to the use of ownership and of inputs and outputs, IP infringement on the third-party copyrights, compliance with regulation, privacy, security. Yeah, it's not a question, but still a comment. Now, Chris Bailey is asking a question. I need to find the term. Okay, so probably two questions and we are done. Chris Bailey is asking, and at intention we use AI-powered search to aggregate and organize public YouTube and Bing private video content into new next generation dynamic enhanced deeper content search and discovery experiences. Is there any possible way we could get into trouble with original content creators and government regulations?
The answer is yes, you can always get in trouble. So again, it depends on few things. As you saw from Thomson case, Thomson Reuters and Westlaw, essentially a large mass of the data set that they analyzed was public court opinions. And then a small head notes for the court, which are like summaries, were copyrightable material. So again, a huge quantity of non-copyrightable materials, meaning that you cannot infringe those, so you could use it, do whatever you want. And then on a small portion. So that's one thing, is that you can always find pieces of information or pieces that have been published, even though maybe publicly published or under some license, there's still some copyrightable materials. Number one. Number two, it used to be, for instance, like Facebook was banning its developers. So if you sign a contract with the developer and they provide you with essentially ability to develop for Facebook or for others, they often don't allow you to mine information. And I know that one of my clients was analyzing effectiveness of the advertising, and actually did come out, and it didn't put anything on Facebook page or their software. It was actually put in a little script on basically users. And by using this script, basically my client was able to conclude that Facebook advertisement at the time were most effective advertising. And despite the fact it was very pro Facebook, sent a cease and desist letter to stop such practices because my client, violated the agreement of not mining information with Facebook without Facebook control. So even if it's in their favor, they might, basically ban you from doing it, even if it might be beneficial to them. So I think if you have huge data sets, I think you will see more and more people are trying to grab it and say, no, that's mine, don't touch it. So similarly to don't mine, don't explore, don't teach, don't touch my stuff, essentially. Again, two trends of a human being, one being kind and sharing, and the other being greedy, accumulating wealth, and then be nice. So we are now at the stage where people will be try to get more and more proprietary with AI use, particularly considering previous developments and previous wealth and all that stuff. Hopefully, I answered your question.
Sorry, yeah. And the final question from Lucky is there a legally determined way to identify or determine AI-generated content? Does it still qualify as AI-generated if the contents are edited?
As I mentioned in my presentation, so it's a judgment call. Right now, there is no one way to say what is AI generated and what AI assisted. So it kind of puts burden on you to show that without you, the quality or the effectiveness or the originality or whatever was the output, whatever the product was, wouldn't be but for the human development. So there is really literally no, and it shouldn't be, because it could be, different products could be in different. It's basically what we call a jury question. I give you one example. In sort of from the previous economy, Gone with the Wind, very famous book, movie. And then there was a lady that wrote a book, and she wrote it essentially without copying almost anything. And that was from the point of view of a slave. So same events and no copying. other than the characters, because the characters were essentially fictional. They were not Robert Lee or, Stonewall Jackson. And that was deemed enough for being an infringement. So similarly, no words were used except for the characters. And the court says, no, that's infringement. So basically you could write about Napoleonic Wars. You just can't use Pierre Bezukhov and others without violating, Lev Tolstoy, but nobody stops you from writing a book about Napoleon. So I think it's an excellent question. And I think, the question itself shows that you were attentive to our today's dialogue. And that's exactly what we're talking about, is that you have to just not to be the slowest deer. So raise your documentation, raise your practices, raise your contribution to the level where you can honestly come and say, listen, that's AI assisted. That's not AI generated.
Fantastic. And on this note, I suggest we start closing our session. Dmitry is an excellent lawyer. A lot of companies that work with us work with Dmitry, and we only have extremely positive feedback. I've shared Dmitry's contacts in the chat previously, and also his website, Dmitry also shared as well. So please reach out if you would have any questions to Dmitry or to us. We're happy to connect you with Dmitry. And with that said, we had a bunch of excellent questions from you guys. Really appreciate your involvement. If you would have any interest of having similar talks on legal or other topics, please reach out to us. I've shared our email here. And for you, Dmitry, I have a final question. What do you have on your heart and mind to close the session and with your final statement?
I think my final statement is let's make sure that Terminator doesn't know where John Connor lives. But otherwise, good luck to all of you with AI use. Just be careful. And before you use it, make sure that you have an understanding your purpose of the use. Basically, exercise diligence in protecting your property if you want to be, want to be yours. But if you also are happy and want to, make this world a better place and make it's all public, it's all up to you. But you gotta start thinking not just about the outcome, but also your place in that outcome. And thank you very much, everybody, for your time. Thank you for excellent questions, and I hope that we'll meet again at some point. And looking forward to your, further questions, either now, later, in email, Telegram. I'm always available. And if you saw, I put a link regarding our Calendly, so I'm happy to talk with any of you later on, and hopefully collaborate and make this world a better place and make you wealthier.
Fantastic. So before you go, we have a final thing, a group photo, which is a group of two of us and a bunch of people on top. So just smile, wave, and 3, 2, 1. Fantastic. So this photo will go on fantastic. Yeah, this photo will go on our social media. And thank you, everyone. With that said, that was Dmitry Dubograev, the founder and managing partner of Femida US, excellent lawyer with a lot of experience. If you want us more talks like that, just reach out to us. We'll bring Dmitry again, and we'll have a very in-depth conversation. Have a great the rest of the day and enjoy the rest of the month. Take care, everyone, and please support us on social media. Bye.
Thank you, everyone.